asesoró a la empresa exportadora ecuatoriana Frutadeli en su demanda en el Tribunal de San Petersburgo por el suministro de banano y que terminó con el pago de la empresa rusa de $748.000. Así que le damos la bienvenida, por favor.
Buenos días, muchas gracias por la invitación. Esta es mi primera vez en Ecuador. Estoy muy contento de estar aquí. Es un gran honor para mí hablar ante ti. Good morning, my name is Roman Saitov. I'm the partner and head of dispute resolution practice at Vic Legal, a Russian law firm. One of key practices of law firm is legal support of global fresh produce industry in Russia. We support our clients by giving advice about various issues of commercial law which arise during trading operations with Russian buyers, and also we represent our clients in court when it is necessary. As you know, commercial disputes are an inevitable part of every company's life, and if a dispute is inevitable, it's better win it. Today I will talk about how to efficiently conduct a commercial dispute in Russia, and more importantly, how to prepare for it in a better way. My advice will be as practical as possible, but this should not seem to be a simplification, because in court battles, like nowhere else, small things and details make all difference. First, a couple of words about the market situation in Russia. We Russians love banana. It is the most popular fruit in the country, number one. And number two is apple. It is necessarily sold in each and every grocery store in our country, including, for example, Magnet store near my house. Since March 2022, the retail price has fluctuated significantly due to the Russian currency exchange volatility and, accordingly, an increase in the purchase prices and logistics. Sometimes, of course, this resulted in decreased demand. But as you can see from this chart, this year, 2024, there has not been any sharp jumps. After the price has reached its peak in February this year, the price more or less stabilized, and since May, we have seen the downward trend. I hope this is not only due to seasonal factors. Right now, one kilo of bananas cost 130 rubles in Russia. So it is even cheaper in August this year. 19 kilo costs $25 if you take official exchange rate. My presentation will consist of three parts. First, I'll talk about know your client procedure before you conclude the contract in Russia. Second, which terms need to be taken into account, and how to conclude it properly in order to avoid issues after. And thirdly, the court process itself. Now, checking your possible buyer. Before you sign a contract with a new counterparty in Russia, you need to carefully check its reliability and business reputation. It can sound obvious, but we know cases when the buyer in Russia pretended to be a supermarket chain, but then just disappeared. You can buy the checkup service from, for example, Russian lawyers for a fee or some other firms, but there are also a number of basic details that you can check independently on your own. It is very simple. First of all, we recommend that you require a so-called ID number of your company in Russia. It is called INN number, or individual taxpayer number, and also a set of essential documents, to which we include the up-to-date company charter and the documents on appointment of the general manager of the company. When you have ID number, it is necessary to check the key information about the company from official sources. There are several such sources in Russia, I mean public sources which are provided by the Russian government. They are very simple, easily accessible, and do not require any registration, and also they are free of charge. So you can just check it on your own. First of all, the tax authority provides the National Business Register on its website. Such corporate register covers all legal entities that are duly created in Russia. So if you cannot find a company in business register, be sure that there are no such company in Russia. You can download the official company certificate or company profile, which is signed with electronic signature of the tax office official, and this can be used as an evidence of official legal standing of Russian company. The certificate is issued in Russian, but you can easily convert it to any other language using, for example, some online tools. The certificate shows a number of essential details, including the official business name of the company, the date of its incorporation, authorized capital, director, shareholder, and legal address. You can pay attention to how long the company has been operating and what amount of capital it has. Second, you can check the financial indicators of the Russian buyer from official financial reports database. The service allows to check out if the company is filing its mandatory financials, and of course it gives you a possibility to evaluate the key numbers of its business, the revenues, assets, incomes, and so on. The third source which you can be interested in and which you can investigate on your own is the commercial litigation disputes database. If a company in Russia has been or currently involved in any commercial dispute, it can be tracked here. Also, it covers bankruptcy cases. The database contains full story of the case. For example, it shows each procedural order, the final decision of the court of first instance, and all upper levels of appeal. The database may give you valuable insight into a company's typical way of doing business. A brief review can show its clients and the amount it operates with. A deeper research in case files that may require additional expertise reveals common types of disputes, typical reasoning, and you can probably see even some questionable contract clauses which can cause disputes between the parties. But generally, if you see from that web source that the company has some proceedings with foreign seller, it can be symptomatic in itself. We have a detailed guide to all these three sources on our firm's web pages. Also, there is a very useful tool called Transparent Business, provided by the tax authority. There you can additionally check tax offenses and fines, the amount of taxes paid by the Russian company, incomes, expenses, and also the number of employees, which can be very useful because it shows the scale of business. In addition to checking the official information, we strongly recommend that you ask your industry colleagues what they know about that particular company and their representative. Because we often see how owners close or even just abandon a company that has been working for several years and quickly transfer all the business to a newly created company, while the managers, bosses, addresses, emails, and all other infrastructure remains the same. So if you see the new name, it should not be misleading because, especially if you see from open sources that the company receives billions of rubles in revenue right after it has been established. Finally, when it comes to checkup procedure, I want to touch one very important issue. It is a well-known fact that if you take private companies, their owners usually prefer to stay a bit aside, or I would say keep a low profile. They do not have any direct ownership in the company, and neither do they have any formal position. But at the same time, they fully control the whole business and even approve each and every payment from this company. So, when we have this in mind, we do not recommend to sign a contract until you have been provided with information on who actually takes decisions in this company. You can ask the manager to whom you are negotiating to arrange an online call, for example, in order to make a personal acquaintance with such person. You can also make a bilateral protocol or minutes of the meeting after that. You can also request a passport copy of that person. It is normal, it's the usual practice in Russia. And it can be also very useful to have a formal director's passport. It can be useful later. Now, the second part, the contract key terms and the contract making procedure. Since we are talking about cross-border contracts between Ecuador and Russia, it is necessary to pay attention to two conditions. First, the law which will govern the relations of the parties, and second, the competent courts which will resolve disputes between them. In this regard, the contract must contain a special section. It is very important, and these conditions must be set out very clear and professionally, because it makes the relationships more stable, predictable, and understandable. As for the applicable law, the parties can choose any legal system they want. For example, they can choose the law of Republic of Ecuador, English law, German law, or whatever they want. But we still recommend to choose Russian law for the simple reason that the dispute against the Russian buyer will most probably be reviewed by the Russian court and in Russian language. So if you choose Russian law, you will not have to prove the content of foreign law, judicial practice, doctrine in that relevant foreign state. You will not have to hire additionally foreign lawyers in order to obtain legal opinions from them. And you will not have to spend time and money in order to translate documents and so on. So simply put, it is just much more convenient for you. I would confidently say that Russian law is quite good. It is good enough in terms of protecting the seller. Our law system is very predictable because we have the codified source of law, the civil code, and also we have systematized legal positions of Supreme Court. So you know what the Russian law is. It was about the law. So now to courts. If you talk about the country whose courts will be competent to consider disputes from the contract, the choice is quite obviously between two countries, between Ecuador and Russia, two countries to which the relationship of the parties are most closely connected. From a practical point of view, I would say that Russia is Russian courts, Russian jurisdiction is the preferred option. I would explain why. Even if your Russian buyer agrees with the jurisdiction of Ecuador and the claim against it will be reviewed here in the Ecuadorian State Court, or for example in the Arbitration and Conciliation Center of the Guayaquil Chamber of Commerce, after that, in order to enforce a court decision or arbitral award in Russia, where most likely all the assets of the debtor are located, it is necessary to apply for a recognition of the decision or award to state Russian court. So it will be a new separate process. Of course, the court in Russia will not hear the case from the scratch on merits, but anyway, it will be a new process. Also, it most likely will be impossible to recognize the decision of Ecuadorian state court because there is no such bilateral treaty between our countries. When it comes to Ecuadorian courts of arbitration, there are no such obstacles for recognition of the arbitral award, but still it requires time and money. Now about Russian courts. In Russia, you can choose in your contract either state courts or the courts of arbitration. What is the difference in what you should choose? The arbitration courts have a number of advantages. First of all, it is faster dispute resolution, 6 months for general rule. It is high quality justice, sufficient attention to evidence and arguments for the parties, less formalistic approach, and I would say more carefully reasoned awards. The decision is final and cannot be appealed if the parties agreed so. The most renowned and reputable court of arbitration in Russia is the International Commercial Arbitration Court at the Chamber of Commerce and Industry of the Russian Federation. The main disadvantage with the arbitration is the higher arbitration cost, because the arbitration fees are much higher than state duty in state courts. For example, if you have a $500,000 claim, the arbitration fees in Moscow will be around $30,000, while the same valued claim in state court in Moscow, you'll have to pay $7,500. When we talk about Russian state courts, of course, I know that there are well-known concerns about Russian state courts, but as far as state arbitrage courts concerned, arbitrage courts are a special branch of state courts that deal only with commercial disputes between companies, not individuals. So, as far as arbitrage courts are concerned, these worries are usually groundless. We, as lawyers, see it as a fairly effective mechanism for protection of your rights in Russia. And this is also confirmed by our successful practice. Briefly about Russian courts. The court process in Russia is faster than in many countries. You can obtain an enforceable court decision roughly within 10 months. It covers two levels, the court of first instance and then the appeal. So if your Russian buyer insists that it should be the state court, not the court of arbitration, you can choose in your contract the court of specific region, because each region in Russia has its own arbitrage court. And the good advice is that you choose or select the region other than the region where your buyer conducts its business. Usually, arbitrage court of Moscow is the good choice. So if your buyer is in St. Petersburg, choose arbitrage court of Moscow. Also, a good idea is to include an optional arbitration clause in your contract. The optional clause means that the claimant has the right at its choice to file a claim either to a court of arbitration or to a state court. So you will have options. If there is a small claim with smaller amounts, you can go to state court because the process is cheaper. While if you have a large amount in dispute, significant case, of course, it's better to go to the court of arbitration. Anyway, if you for some reason still strictly disagree with Russian jurisdiction, I mean, you do not want neither the state court nor the court of arbitration in Moscow, we recommend the contract agreement that disputes to be referred to a well-known arbitration center from some so-called Russia-neutral jurisdictions. For example, Dubai, Turkey, Hong Kong, or Singapore. The traditional Western courts of arbitration should be avoided these days because of sanctions and bureaucratic restrictions. In August this year, the Supreme Court said no to recognition of the foreign arbitral award because the place of arbitration was located abroad and some of the arbitrators were citizens of so-called unfriendly states, so this was regarded as limited access to justice. So this must be avoided. To sum up about the law and the courts, please do not ignore the dispute resolution section in your contract. Choose Russian law and choose the court of arbitration or arbitrage court of Moscow in your contract, because it is very important for effective protection of your rights. If we talk about commercial terms, I would say that it is important to pay special attention to the rules of goods acceptance procedure. This is the section of the contract which we lawyers read first when we see that there is a quality dispute, and regrettably, this is the section where we most often see significant imbalances in favor of the buyer. If we, for example, take contracts with templates from large Russian retail chains, here are some terms that are clearly disadvantages for you and which must be avoided. First, note the right of the buyer to carry out acceptance in the absence of a seller representative with making unilateral documents, a survey report or an acceptance certificate. The second is the right to conduct a so-called selective inspection of the shipment by selectively opening some boxes, and here even one box can count, while the results of such inspection are applied to the whole shipment. Of course, it is not good for a seller. Such terms should be avoided if possible. It is necessary to insist on joint surveys from the very first box. We do not recommend to rely on experts from the survey company hired by the buyer. Always send your own surveyors. It is important. Of course, I'm well aware that Russian retail chain will most probably try to defend its contract by arguing that it is applied only as it is, because it is the template which is approved internally in this corporation. But in practice, in reality, we see that Russian purchasing managers have fairly broad powers when it comes to various commercial terms and conditions, and they can change, make changes to standard contract by concluding many additional or supplementary agreements to it. And sometimes such supplementary agreements are signed even simultaneously or same day with the contract itself. In any case, if your objections regarding particular terms of a contract are rejected, for example, if you said, I don't want to see such term in my contract, in spite of this, the buyer insists on that, and you have to agree, your objections, even so, may be useful, because if such terms are fairly, clearly unfair, you can challenge such terms of the contract later in court, separately or jointly with any other claim if it will be necessary. Also, a brief comment about the quality. The chains usually propose the quality tolerance standards in their contracts, that is, the proportion of goods with defects, non-standard or waste, that are not considered as violation of the contract. At the same time, such standards are published in the official purchasing rules of such retail chains, which we place at their official websites. Such official standards can be called in different ways. For example, quality passport or quality certificate or quality specification, so on. We recommend to check if the tolerance that the buyer requires for you under the contract comply with its official rules. If there is a mismatch, you see that we require more than is stated in the official rules. Of course, you can ask a question from the manager, why are you being subject to increased requirements? And by the way, the official rules should also be used in case of dispute of the specific management, specific shipment, because we set out in details and with illustrations what exactly is considered to be a defect and what is not. Now I go to the contract making procedure. This is also an important issue because in almost every second case that we conduct, the buyers raise objection that we did not enter into a contract at all, even if they bought the goods from you for several years. Now, general rules. According to Russian law, the contract between legal entities must be concluded only in writing. It is allowed to conclude a contract by way of exchanging the email exchange of scanned copies. A draft contract is usually prepared and sent to you by Russian counterparty, by Russian buyer. And the law does not require the buyer to sign such a draft contract. It can be qualified as an offer without a signature, even if it came to you in a simple Word program format. However, the buyers often try to escape from obligations by arguing that there is no contract with their signature seal. Our advice in this regard is that you never should be the first to sign either the contract or additional agreements. You should always require the scan of a signed contract from your Russian party. and only after that, after you received it, you can sign it, scan, and send back. It is also equally important to have evidence of that the offer to conclude the contract, that draft contract came from the particular Russian company, because often in courts the buyers denies any connection to the person who corresponded on his behalf. They say just, we don't know who the person is, they did not represent me, it is not our company's email address, and so on. So taking this into account, it is necessary to request the evidence from the counterparty at the early stage that the email address really belongs to this company. Of course, it should be also included into the contract along with other details of the Russian company. Now I go to the court process, my favorite topic. And I have a couple of general considerations that I would like to share to you. The main advice which we give to our clients is, please do not wait for too long. Because with each missed month, the chances for successful recovery, debt recovery, decrease. As you know, even a clean and good company can eventually go bankrupt. And if you are talking about private company, the beneficiaries can liquidate this legal entity or simply leave the company and transfer the business to a new legal entity. Of course, this doesn't happen every day, maybe once in several years, but it still can happen. In this case, it will be, of course, much more difficult, longer, and more expensive for you to restore your rights and get the money back. In addition, an important point is that over time, the available evidence inevitably disappear because the important correspondence or other important documents can be missed, can be lost. The employees, your employees, for example, who could and wanted to act as witness can leave the company and so on. So you are left with less evidence. The general rule, in our opinion, should be as follows. If a delay has reached 3 months and it has not been possible to agree in a regular course, it is necessary to proceed without delay to formal procedures. The first step here is to send a formal pre-litigation or so-called pre-arbitration letter of claim. It is very simple. You can easily do it on your own with your internal forces. But we recommend to involve external counsel already at this stage, for the reason that the external counsel can prepare a high-quality legal reasoning for your claim with due account to applicable legislation. And more importantly, they can establish a good working communication on the ground in Russia. Sometimes this alone is enough to reach the settlement without a court, and we have had such positive cases in our practice. And our general advice is be as proactive as possible, always, from the first day of cooperation. Defend and protect your rights. Because when the dispute has moved to the courtroom, the judge or arbitrator retrospectively examines and evaluates how the party behaved during the contract. And if the judge sees that you confidently and consistently proved your case, for example, you sent not one payment reminder, but a dozen of reminders, or you replied to any quality claim in a well-argued manner, then the position which is prepared by your lawyers in Russia, of course, will be perceived more convincingly. Simply put, you will just have stronger case. It will help you. Don't afraid to look impolite, because Russian culture often described as very straightforward and emotional. We say what we mean, so you should act in the same way. And our general comment about the culture is that if a company in Russia receives a lawsuit, it is not an extraordinary. It is said in Russia that so-called business disputes are an integral part of any business's life. That's why going to court does not necessarily mean that cooperation with this buyer is inevitably ended for you for all times. There is still chance that you will be partners in the future. And this is true both retail chains and private companies. Even if you had to hire lawyers and start a process, the door must be left open. Our firm always, whenever possible, strives to help settlement so that our client receives the adequate results here and now. And in our practice, 40% of court cases ended in friendly settlement agreements. Some of them in the court of first instance, but some of them even in court of appeal. So you should have the door be open and continue your communications channels with the buyer. If we talk about practical things, my main advice is please carefully save and keep all your evidence, because when a dispute goes to court, nothing is more important than evidence. And this is especially true for the correspondence. Even a single email of several hundreds can significantly affect the whole case. And this is true for all employees. Even for your director, logistic department, commercial department, accounting, and so on. Please take it as granted that there are no unimportant or so-called technical letters, because any of them can be important. The mail server may collapse, the employees may leave the company, so it is crucial that you regularly store and keep your evidence, especially correspondence, in a safe and separate place, and preferably in a systematic way. Believe me, it's a crucial part of your defense. So now I go to the typical defense that the buyer can raise in response to your debt recovery claim. It can sound as a surprise, but be prepared that they will deny and challenge each and every fact, even very basic ones, even if you, no matter how long you know them and how long they bought your goods. First, as I said, in every second case, the buyer declares from the very beginning that it does not have a contract with the seller. The recommendations here are very simple. Keep all correspondence about making the contract. Do not sign the contract first and do not send it first. It is also necessary to keep emails about sending invoices for payment. In our practice, we have had several cases where we were able to prove that such invoices should be considered as a binding contract itself. Next, the buyer can claim that it did not receive the goods at all. It is less often nowadays, but previously it was quite popular line of defense. In your response, it is necessary to provide copies of BLs signed and stamped by a shipping line representative. Also, we recommend that you immediately after the voyage vessel is over, save the container tracker report from the carrier's website. It is important because sometimes the system does not allow you to download and to track older voyages. In addition, you can request a letter of confirmation from shipping line about the containers with the dates of shipment, arrival, and delivery to consignee and return after unloading. Next, very often buyers choose to challenge the price, and they say that they have been paid for all goods are paid. They claim that they never received such invoices as the seller submitted to the court, and instead of that, they refer to their import declarations, which surprisingly show absolutely different price. Again, you need to keep all emails about sending invoices. Always require a return email with confirmation receipt. For example, you send them invoice for payment, please do insist that they will confirm you back that they received it. You also need to keep all correspondence about price agreement. It is crucial that you have a bilateral price agreement in any form you want. It can be the monthly plan of shipments, it can be yearly plan, it can be so-called specifications, letters, protocols, whatever you want. But the main rule is that you must have such bilateral price agreement, and it must be signed by the buyer. Please do not rely on WhatsApp or email agreements about the price, because it finally will be challenged by the buyer. Also, it can be important that you insist that the buyer, when making payments, indicate the specific invoices that it pays, and not just for fruits, because sometimes they try to prove payment of unpaid goods by reference to the payment orders or SWIFT that actually relates to absolutely another shipments. So check invoices. They must indicate what they pay for, your specific invoices. Next, quite often buyers refuse to pay, saying that the goods, as they claim, they received with defects in quality. The best way, of course, is to carry out an inspection and have a survey report with videos and pictures for each shipment at the time of departure. Because under Russian law, the seller is responsible for defects only if they occurred before the goods were conveyed to the buyer or to the carrier. Also, as I mentioned, it is important to have a surveyor, your own surveyor, in place at the time of acceptance after the goods has arrived to Russia. If you have received a quality claim, please study the survey report very carefully in details down to each photo and send your reasoned objections if you see that it can be unreasonable. We have browsed thousands of photos from retail chain survey reports, and we several times saw the pictures of port personnel staying or walking just over the boxes, which obviously cause the new harm to the goods for which the seller cannot be responsible. Also, pay attention to the deadlines for responding to the claims according to your contract. If it happened that you still have to sign the quality claim, you can mention in your cover letter and your email that you do not agree with such claim in substance. This can help later. Next, twice in last 2 years, we've got the cases that the buyers did not challenge that they received the goods from our client, but they claimed that it was only the shipper or consignor, while the goods were purchased from a third party under an agreement with such third party, and the buyer allegedly had no payment obligations to our client. So, in simple words, they say, yes, all right, we confirm that we received this shipment from company A, but this company A was just a shipper. We just send their goods to us. At the same time, we bought these goods not from the company A, but from absolutely another company B, with which we have a contract and to which we must pay. That's why we don't owe you any money, and the claim must be rejected. In support of this version, they submitted the old contract with that third party, which could be real, and also a bunch of fabricated documents, namely the additional agreement to that contract that the delivery would be carried out by our client, as well as fabricated specifications and invoices from this third party, which included our client's goods. The cases were complicated by the fact that they had previously submitted the same fabricated documents to a customs authority when importing goods. And when settling with our client for other shipments, they indicated the same contract with a third party and additional agreement as a basis in their bank. In addition, then they submitted customs declarations to a bank. In addition, they also submitted customs declarations to their bank based on such false information. Neither the bank nor the customs authority checked if the documents and information were true and accepted them as they were. As a result, the buyer's legend or version or defense could seem quite honest on the surface in court. These were very difficult cases. We struggled against this by proving that the documents on behalf of that third party were falsified. In one case, the buyer even placed the signage of the director of a foreign company who, as we learned, had left his director position 3 years ago. We also collected the significant, extensive evidence base, which was to show that the goods they actually ordered, bought, and purchased from our client. The correspondence again and the witness statements are the key role here. What we recommend that we send is that in addition to careful treatment of correspondence, as I have already said, you can check the purpose of payment in SWIFT, which buyer sent you. For example, we say, we sent you money, here's the SWIFT. You should open it and carefully check the description of payment or intended purpose of payment. And if you see that there is absolutely irrelevant contract which you know nothing about, you should be cautious and you should ask the question to your buyer. It's also useful to request a copy of import declarations from a buyer from time to time in order to check the documents, to see what kind of documents we show to customs as a base of importing the goods and which price do we show. Next, we have also seen situations where the buyer accumulates a large debt and then terminates a long-term contract saying that the seller had previously allegedly violated quality requirements. Then it refuses to pay the debt because after that it allegedly bought the goods instead, the goods that remained under the contract from other buyers in the market at a higher price. And they say that by this, this caused harm to us, we incurred losses, and we set off our losses against the payment obligation to you. They say, we have losses, and that's why we don't owe any money. The basic recommendation in this case is to prepare for dispute on quality from the day one after the contract. You should be always prepared that the contract will or may end up in a quality dispute. So that you can prove that the termination of contract is groundless and there were no sufficient grounds for termination. If the contract allows, and you can, if the situation allows, it is necessary to include in the contract a prohibition on any such unilateral set-off on the part of the buyer. Finally, of course, the unreasonable termination of contract can cause harm to you, can cause losses which are connected to preparation to your deliveries because you bought some materials, stock, and so on. That's why you should keep all the evidence of the materials bought, for example, branded boxes, thermographs, plastic bags, stickers, and so on, all this material. That is all. I hope my advice will be useful. Again, thank you very much for your kind invitation. I'm very pleased to be here. Thank you for your valuable goods, and I wish you every success and the best of luck in Russia. If you have any questions, I would be glad to address it.